Welcome everybody to this, the second of the autumn series of the Quadcast Shipping Special. I'm Nigel Cooper and I'm joined by James Turner, Caroline Pounds and Paul Henton. As ever, we welcome your questions. Indeed, we've had a few already and we'll try to address those as we go through. So please do get in touch using the Q&A function if there's anything you would like to raise. Of course, that means I have to tell you what the topic is we're going to talk about. And that is the topic we're going to discuss today is one which we have all come across in the course of our practices. It's also one which will be commonly encountered in many shipping transactions or in other areas of the maritime industries. That topic, of course, is the question of when is the deal done, with specific reference to the potential impact of contractual subjects. The use of subjects is routine and one might expect the answers to our questions to be straightforward. For example, we're all familiar with fixture negotiations, where one has a chain of contractual recaps on subjects before a clean fixture is declared. Such negotiations are an everyday occurrence. But many who use subjects in this way would be surprised at the level of debate in both the case law and in academic commentary as to how subjects are to be classified. How does one distinguish between a subject which prevents a contract arising and a subject which does not have that effect, but merely suspends a party's obligation to perform the contract until the subject has been satisfied? Does it make any difference to a party's potential liabilities how a subject is categorized? And if so, what are the consequences for getting it wrong? Now, these are all questions with which Mr. Justice Foxton recently grappled in a case which I try and pronounce as the Leonidas, but I suspect you may hear other variants through the course of today. We will in turn provide our views as to the answers to the questions, but also ask, does the Leonidas bring clarity to a difficult area of law? And how does one go about ensuring that a contractual subject has its intended effect? Caroline, do you want to sort of kick off and tell us why the law in this area is so difficult?
Yeah, I mean, I think let's start by going back to basics. As you said, what we're talking about are contractual subjects, and broadly speaking, there are two types. First, there is the type of subject which can prevent a contract coming into existence at all. Now, that is where the effect of the subject is to defer the party's intent to enter into binding legal relations until the subject is satisfied. Classic examples would be where the party's contract subject to contract or subject to details. The other type of subject is where there is an otherwise binding contract, but which is subject to a provision which makes either the existence of the contract or its continuance, or perhaps just a particular obligation within it, subject to the occurrence or the non-occurrence of a contingency. Now, those type of subjects are usually known as contingent conditions. Classic example would be a contract of sale, which is subject to export license. In that type of situation, there is a contract which the parties intend and have agreed to conclude, but the contract won't be effective and the parties won't be obliged to perform it unless the export license is obtained. Now, contingent conditions then subdivide, at least in theory, it can actually get quite complicated as we'll see, into conditions precedent on the one hand and what's called conditions subsequent on the other. And very simply, a condition precedent is where the condition prevents the contract or an obligation within it coming into existence unless the condition is fulfilled. A condition subsequent, on the other hand, is where the condition provides for the determination of an otherwise binding contract or obligation on its occurrence. Now, the important point about these contingent conditions, as their name suggests, is that they involve contingencies which the parties don't promise to bring about. And that's important because the non-fulfillment of the condition, therefore, doesn't itself give rise to an action for breach. Liability can arise in other ways, as we'll see a little later. And now those contingent conditions need to be distinguished from what's called promissory conditions. Again, the clue is in the name, because a promissory condition is a condition that one party to a contract promises to fulfill and which must be satisfied before the other party is liable to perform its obligations under the contract. Again, to give a common example, take the promise by a buyer in a contract of sale to open a confirmed letter of credit in favour of the seller. If the buyer does not perform that promise and fails to open the letter of credit, then the buyer will be in breach, the seller will be discharged from its own obligation to perform, and will be entitled to claim damages. Now, the distinction between these various types of condition, promissory conditions, contingent conditions, conditions precedent and subsequent, is, in theory, it's one that's easy to draw, but it's not always easy to apply in practice. And the terminology itself can be confusing, not helped by the fact that different commentators and different judges, right up to the highest levels, have on occasion used the terms interchangeably and sometimes even in the wrong sense. To add to that, we now have Mr. Justice Foxton in the Leonidas. I'm not sure, Nigel, whether that's how you pronounce it or not, but that's how I pronounce it. But what he's done is draw a distinction between preconditions on the one hand and performance conditions on the other. Now, that's a terminology that appears to be new, no doubt born of an attempt to simplify matters, but whether or not it does so is a rather different matter. Now, I think, Paul, you were going to begin by telling us about the facts of the case and exactly what it was that Mr. Justice Foxton was called upon to decide.
Yeah, happily do that. So the facts of the Leonidas, I should say there's actually a chip shop near where I live called Leonidas, which I think I've been pronouncing incorrectly the whole time. But this has taught me something anyway. A routinely encountered type of dispute, as Nigel said, but as ever, the devil is in the detail. The facts in very brief outline were the parties were negotiating a voyage charter for the carriage of crude oil from the Caribbean to the Far East. The negotiations had reached a stage of a fixture recap on subs. So as we lawyers would say, a non-binding agreement in principle, or as those in the market might say, a deal on subjects. And the critical subject in this case were the words "for account of the charterer was subject to charterers," as in CHTRS, charterers /S/S/R/MGMT approval, latest 1700 hours, Houston time on the 12th of January. And it was common ground that that acronym meant that the deal was subject to STEM, that's the first F, so subject to enough material. The second S was supplier's approval, and then receiver's approval, which was the R, and then charterer's management approval. With the 12th of January deadline looming, the parties were continuing to negotiate by email and by text and by phone, and the owners were pushing the charterers to lift their subjects and to accelerate the conclusion of the fixture, whilst the charterers are taking the position that they needed more time to lift their supplier's approval subject. It was common ground that an oral discussion was held, during which the charterers agreed to lift all their subjects, with the exception of the supplier's approval subject, in exchange for a reduction in the demurrage rate and a 24-hour extension of the deadline for lifting the final subject. That deadline came and went, the final subject was not lifted, and the charterers took the position that they were at liberty to withdraw from the negotiations. I'm sure everybody can guess where this is going. The owners took the opposite position and brought a claim for damages for repudiatory breach. So the owner's contention was that a fixture had been concluded, albeit one which would cease to be binding if it was not possible for the charterers to lift the supplier's approval subject, despite taking reasonable steps to do so. So that's the performance condition analysis. The charterers said no fixture concluded. This was just one of those typical cases where we're on subs, effectively a subject to contract type case, and we pulled out whilst one of those subjects was not lifted. So that's the focus of our discussion for today. A couple of other interesting points arose, which we'll touch upon if we have time. Firstly, if the owners were right and there was a fixture subject to a performance condition which the charterers hadn't lifted, how should the court assess damages? Do you assume that the supplier's subject would have been lifted and make an award of contract market damages? Or do you make some other assumption? Do you assume the fixture would have ceased to be binding in any event for non-performance of the condition subsequent and award nominal damages or some sort of halfway house? And then the other point which came up was an alternative argument which was run by owners, which has raised a bit of debate amongst some of the questions we've been receiving in advance of today. And that was an argument that the parties had, by their conduct during the 12th and the 13th of January, affirmed the fixture in any event, despite the non-lifting of the supplier's approval subject. And we'll come on to that one if time permits. But James, why don't you go ahead and analyse to death Mr. Justice Foxton's analysis of the law and on the main subject to suppliers approval point.
Well, I'll do my best. I don't think time permits me to analyse it to death. But I just have to say in passing, Leonidas to me had always been Belgian chocolates, but I'm glad that you've brought me down to certificate. Well, on the law, the judge started with the basic principle that you have to look objectively at the parties' communications and conduct to see, firstly, if they intended to create legal relations, and secondly, if they had agreed on all the terms which they regarded or the law requires as essential for the formation of legally binding relations. As regards subjects, now parties may agree to negotiate subject to contract or subject to details, as Caroline has said, and that usually means that there is no contract at all until it has been formalized or until all the terms have been agreed. But it's important to bear in mind, and this is the affirmation point, that even when the parties have agreed, for example, subject to details, they can always change their minds. But unless and until they do, the effect of those phrases is to postpone the decision to enter legal relations and rule out the possibility of preliminary obligations to try to complete the bargain. Now, the judge called subjects of that sort preconditions, and he contrasted them with what he called performance conditions. A performance condition does not prevent a binding contract from coming into existence, but means that, and to quote the judge, performance does not have to be rendered if the subject is not satisfied for reasons other than a breach by one of the parties. So the key issue in this case was whether subject to supplier's approval was a precondition or a performance condition. Was there no contract until the condition was satisfied, or a contract which obliged the charterer to exercise reasonable endeavours to get it satisfied? And the judge went through some of the factors that may be relevant to classify the subject as a precondition or a performance condition. The first was that if its satisfaction depends on the decision of one of the parties, it's more likely to be a precondition. But if it depends upon a third party, it's more likely to be a performance condition. But of course, not all subjects fall into one category or another. Subjects dependent upon one of the parties contracting with a third party will usually be preconditions. But again, that's not always the case. Think, for example, of Caroline's letter of credit example. That's a contract with a third party, but that is generally treated as a performance condition, and indeed a promissory condition at that. The normal position is that a subject is more likely to be a precondition if it involves the exercise of personal or commercial judgment by one of the parties. But in a shipping context, on subs is widely understood to signal that preconditions are outstanding, so that agreement is dependent on one party or both lifting subjects. And indeed, if a subject has to be lifted by one or both parties rather than occurring automatically, then it is likely to be a precondition. And the final factor is that a short deadline within which the subject has to be lifted is again more likely to be a precondition. And the final point that I would draw attention to before handing on is that what one sees in the judgment is a judge paying very close attention indeed to the commercial and practical realities when considering whether the particular subject is to be classified as a precondition or a performance condition. And so one of the takeaways from the case is definitely that if you want to present a legalistic and uncommercial argument, the commercial court, certainly with Mr. Justice Foxton sitting in it, is not the place to do that. But now, Nigel, I think you're going to bring us up to speed with how the judge applied those principles in this case.
Certainly, James, and as you say, he did take a very close look at the factual and contextual background to the recap and construed it in that light. And when he came to analyse the requirement for approval of the vessel by the charterer's supplier, there were a number of factors which influenced his decision that it was a precondition preventing a contract arising until it had been fulfilled, rather than a performance condition. He accepted that, taken on its own, it was possible to argue that the requirement for supplier's approval was a performance condition, but he concluded that, in fact, it was a precondition for a number of reasons. First of all, as a matter of long authority, subject stem and subject management approval are preconditions, and that he was not prepared to suggest that those authorities might be wrong, nor was he prepared to distinguish them. Where, therefore, other approvals are wrapped up in the same clause, it would be surprising if those approvals had a different status. Secondly, he held that the requirement for suppliers or receivers' approval all related to matters concerning the commercial desirability of the charter to the charterers. And in that respect, to the extent that the owners were looking to rely on cases concerning the obtaining of import or export licenses or other forms of third-party approval as pointing to a performance condition, he said that where you look at matters concerning the commercial desirability of the charter, that is something that is qualitatively different. Thirdly, he said there was a surprising degree of uncertainty as to what the subject was intended to mean. There was no customary meaning as to what subject supplier's approval means. And it was clear on the evidence that owners and charterers considered that it had different meanings. Charterers, the approval of their seller; owner, the approval of the terminal. And that uncertainty, in the judge's view, spoke against the subject being intended to create some form of contractual obligation.
It's a great passage. It's a great passage in the judgment, that, isn't it? He goes on for about 3 pages, looking very carefully at the various arguments being put forward as to what this actually means, and then comes to the conclusion that you can't say.
Exactly, and in a sense, that does raise the question: if this judgment was intended to provide some legal certainty to the process of construction, does it achieve that? But just going back to the factors, the judge's factors, he considered the clause was one which related to all the approvals which the charterer would commercially wish to obtain, and looking at the position of FOB suppliers in a number of well-known standard conditions was, in his view, significant to the approach as to how one construed this clause. And he pointed to the fact that the charterer might still be in negotiations with other suppliers at the time of the fixture negotiations, and it would be surprising if a clause in the fixture recap was intended to limit the choice of the charterer as to who its ultimate supplier might be. Now, I think when one looks at the facts of this case, it's difficult to undermine the judge's reasoning. But going back to what you were saying, James, the extent to which he looked at the facts and brought that commercial context into play in terms of construing the clause does kind of make one question how far, going back to what I was saying earlier, how far, if the facts were different, would we have reached a different conclusion? I don't know, Paul, what do you think?
Okay, well, yeah, I could maybe throw open a bit of the discussion by reading out one of the various questions which came in advance of this. I've got a few messages on my desk. One of them says, "Looking good, Henton, give us a wink," but that's not the right one. I can probably summarize it like this: would the charterers have been bound if the supplier had been a related entity in the charterers group? Was the question we received. I think that's getting at the distinction which James mentioned between subjects which are lifted almost automatically, like the import license, export license, turning on the decision of an authority, versus and are therefore more likely to be performance conditions, versus subjects which depend on the outcome of a contractual process with a third party, which would be more likely to be a precondition. The reason being that the courts are reluctant to enter into inquiries regarding the likely outcome of a process of contracting with a third party. And so I think actually on the evidence, there was a fair bit of evidence that the charterers were going to quite great lengths to try and procure a rejection from the supplier, because they thought that would help them to build their case that they weren't bound. So I don't know. I think on those facts, if you take out of the equation the fact that they are dealing with an arm's length supplier, and so you've got that element of, well, will they be able to reach a deal with their supplier or not? That maybe starts to move things a little bit further in the owner's direction, on the basis that, well, that approval would have been forthcoming if you've got a situation where it's it's a Ruritania oil terminal and Ruritania Oil brackets Chartering Limited, and they're effectively one and the same entity. I suspect, having read Mr. Justice Foxton's judgment and the way that he wanted to treat all of the subjects together in the same way, well, if parts of the clause are preconditions, then surely the whole lot of preconditions is just the bundle of things that the charterers wanted to get approved before they would agree objectively to be bound. I suspect that actually that wouldn't have turned it on the facts, but obviously it's a pretty fact-specific inquiry. So shall I throw that to the floor? What does anyone else think?
I mean, that's the point, isn't it? With all these types of questions, they are so fact and context specific. So, I mean, on the one hand, it's great that we've got this decision in the Leonidas, in the sense that we've got, on paper at least, some clear guidance in terms of the distinction between preconditions on the one hand and performance conditions on the other. But I mean, how easy is that to apply in practice? It does seem to me that there are two real areas of difficulty. First, and notwithstanding the guidance that we've got, I think it's still quite difficult on many occasions to distinguish between a precondition and a performance condition. You've then got another difficulty, which is that even if it is clear that something's a performance condition, you can get into quite difficult questions regarding the nature of the obligations that one or both of the parties might be subject to before that condition is satisfied. And that's something that I don't think we really learn a great deal about from the judgment itself. But going back to the first difficulty, first of all, and this is simply distinguishing between preconditions and performance conditions, notwithstanding the guidance we've now got, we've actually had two interesting questions on the Q&A I see, and that they're both quite similar. So let me try and mold them together. The scenario we've been asked about is this. You have a fixture recap, which has been negotiated, all of the terms are agreed, but the recap is expressed to be subject to charterer's reconfirmation by 1800 hours the next day. Now, in between the fixture recap being agreed and before the deadline for charterers to provide their reconfirmation, owners get cold feet and pull out of the deal. The question we've been asked is, can they do so? Is the term subject charterer's reconfirmation similar to subject to contract, subject to details, and thus preventing any binding fixture coming into existence at all, meaning both parties can just pull out? Or is it more of a performance condition and are owners in some way bound? Who wants to answer that one?
Well, I'll kick off. I think that in that circumstance, owners are bound. I know that it's very similar to, in fact, for all intents and purposes, identical to management, subject to management approval. And in paragraph 46 of the judgment, the judge says quite clearly that's a typical precondition. You're postponing the intention to create legal relations. But I think it would be an odd result commercially, for a start, for one party to have an express veto, in effect, subject to charterer's confirmation by 6 o'clock tomorrow, and yet for the other party to have an unagreed and implicit veto. And if the analysis is correct that it's about intention to create legal relations, well, then perhaps the answer is that owners do have that intention at the time of agreeing all the other terms.
I mean, I think I agree, James. I find what Mr. Justice Foxton says in paragraph 46 really quite difficult, because he says as a sort of trenchant statement that if you've got subject to board approval, and I think what he says is this: no contract comes into existence when an agreement is reached subject to board approval. Now, I actually have two difficulties with that as a statement. The first is that the consequence of that is there is no intent to create legal relations, and I find that very artificial for the reasons you've just said. And the other difficulty I have with it is that I know there are certain phrases where it's very well established in the authorities what they mean, but I actually think it's quite dangerous to say in respect of any of these phrases that they have a particular meaning, because I think the meaning can take on different shades depending on the particular contract or putative contract in which it's contained. You've always got to look at the context, and you've always got to look at all the terms together. So I think it's actually quite dangerous to say, well, this phrase necessarily means this, because it might mean that in one contract, but in another, it might mean something slightly different.
Well, I'm going to throw in an alternative view, if I may, because isn't the difficulty if the phrase is construed as a performance condition, then you're past the difficulty of have you got an intention to create legal relations or not. But if the intention is that the purpose of that subject to charterers reconfirmation, whatever it may be, whatever the phrase may be, is that charterers are saying we do not want to be contractually bound in any way until we have got that reconfirmation, or we have got that board approval, whatever it may be, then you have a scenario where in response to an offer from owners to contract on particular terms, charterers have in effect counter-offered and said, we will charter on those terms, but only if we have a further period of time within which to reconfirm. And charterers' message or charterers' terms in that respect are in effect a counter-offer, which means that at that point you have nothing in the way of either offer or in the way of an acceptance, which allows you to say that owners are somehow bound to contract on those terms if charterers give the reconfirmation. My own view is that certainly if you look at the Leonidas, if you look at cases like Goodwood Investments and the Junior K, there's a very strong case for an analysis that says that until charterers have given their reconfirmation, there is no acceptance of owners' offer. And therefore, until the point of acceptance, owners are entitled to either withdraw or indeed put forward alternative terms. And in a slightly different context, that's what happened in the Goodwood case. It was subject to builders board approval. Parties went off. Builders then came back with a completely different set of terms. And court found no concluded contract and no obligation on owners to be bound by only going away to seek board approval.
But the contract in that case.
What do you think, Paul?
No, I agree with that. And we should say Goodwood is the case that's cited at paragraph 46 of Mr. Justice Foxton's judgment, which James mentioned. I suppose there's two things. The first is our clients want to know what's likely to happen rather than what we think is really interesting. And on the face of the law at the moment, it looks very much like the weight of authority is in favour of there being no concluded contract in that scenario. It's like a board approval or a charterers reserving themselves a right to veto or a right to postpone their decision to enter into legal relations until a later stage. If they can do that, then it seems to me the analysis is that it's done. And accordingly, you've got an offer which is unaccepted and which can therefore be withdrawn. It does seem to me that the owners aren't under some sort of obligation to sit and wait and find out whether the charterers say yes or no. And in the meantime, they can't pull out. And I think there's another part of Mr. Justice Foxton's judgment which is very clear, which is that where you have a situation where it's precondition rather than a performance condition, there is no implied obligation. There's no room for imposing some form of preliminary obligation on the parties to complete their bargain, because that would be like an agreement to agree or something like that. If you've postponed the point at which you objectively are going to enter into legal relations, you haven't reached a deal, then either party can withdraw, it seems to me.
I couldn't disagree with you more on this, Paul, very quickly, because I'm conscious we're running out of time, but just two quick points. Firstly, the Goodwood case, if you actually read it, not only was it subject to board approval in that case, it was also subject to execution of a formal contract. So of course, the decision in that case is obvious. I do think we are dealing here, to go back to not my terminology, but the terminology we discussed at the beginning, with a contingent condition precedent. It's not that there's no intent to create legal relations. It's just that if the board approval is not given, then the contract won't be effective. And for the person who asked this question, you might want to have a look at a 2006 LMAA arbitration decision, where the phrase was considered, and the tribunal in that case held that it was in fact a contingent condition subsequent. Most conditions precedent can be expressed as subsequent and vice versa, so it gets quite complicated. But the important point was, in that arbitration decision, which I personally think is right, the tribunal did find that yes, the charterers could walk away because it was subject to their board approval, but the owners were in fact bound up until the deadline for that confirmation to be given had passed.
Well,
but anyway,
what we have 10 years before Goodwood. Anyway.
Yeah. I think what we're getting to is a point like this, isn't it? And I would explain at length why I think you're wrong on Goodwood, Caroline. But what you can see here is perhaps the only takeaway is that there's a leader and junior on both sides of this argument, should it arise in future. But you earlier on, Caroline, you mentioned the question of the obligations the party might be under if it's a performance condition. I don't know, James, were you going to add to that discussion?
Well, I think at this stage, in view of the time, only to say that if we're into a performance condition, then one has to consider, as Caroline mentioned earlier, the extent of the obligation on the party whose subject it is to bring it about. And that may be as little as not taking active steps to prevent it coming about, through obligations to act bona fide, to exercise reasonable endeavours or best endeavours, but obviously stopping short of promising that it will happen, because that's then a promissory condition and not a contingent one at all. But the view taken in most cases tends to be that it's an obligation to exercise reasonable endeavours to bring the subject about, and that's very much how it was argued in the Leonidas, without there being very much argument about it at all. In different cases, obviously, that can be absolutely front and centre of the arguments that are keeping the parties apart. But I think more interesting, perhaps, in the time we've got left, is to look at, I'm just seeing a very interesting questions coming up on the Q&A, which is why I'm hesitating. Just to touch on the question of damages, Nigel, you were going to tell us something about that.
Certainly. Well, just very briefly, as you say, so the arguments from owners on damages, if they were right that charterers were in breach of a performance condition, was that, first of all, as a matter of causation, it was for charterers who to bear the burden of proof to establish that owners would have suffered a loss in any event, because charterers would not have been able to comply with the performance condition, even if not in breach of contract. And they also ran an argument that in any event, as a matter of the assessment of damages, charterers were to be treated as having waived the performance condition, such that damages were to be assessed in any event on the basis that charterers were in breach for not performing the charter party. Now, the judge rejected both of those arguments and held that as a matter of causation, the ordinary principles applied, so that it was for owners to establish what loss and damage they had suffered as a consequence of charterer's breach, and that there was no particularly special standard of proof, only the balance of probabilities. Secondly, on assessment, he held that the proper approach was to determine owners' losses on the basis of the doctrine of loss of chance. And then he went on to assess what the likelihood of charterers obtaining the necessary approvals would have been, depending on how one construed the requirement for supplier's approval. Now, so far as owners' arguments were concerned, the judge rejected them, both in relation to causation and assessment, on the basis that the authorities owners were relying on were confined to their specific circumstances. So in relation to causation, he held that the authorities relied on by owners concerning obligations to obtain import and export licenses related to clauses which in effect operated as exception clauses, and therefore imposed an obligation on the party in question to justify why they had not complied with that exception. And he didn't consider that was an appropriate analogy for the facts of this case. Secondly, in relation to assessment, he wasn't prepared to treat charterers as having waived reliance on any performance condition, because he regarded the relevant authorities, such as Mackay and Dick, as being concerned with obligations in debt rather than assessment of damages. But Caroline, I think you had some points on loss of chance and what difference that doctrine makes in cases like this.
Yeah, I mean, look, I can't even say it at all now. The Leonidas is interesting for its discussion at this point. And the loss of a chance analysis, in my view, is obviously preferable to one which sort of deems the condition to necessarily have been fulfilled, because it seems to me that's just a fiction. But I do wonder on how many occasions in practice will you actually have to resort to that analysis? Because I mean, I think in the Leonidas, it all goes back to the fact that Mr. Justice Foxton had found that the meaning of supplier's approval subject was so uncertain. And so in that situation, given that he found it difficult to know what the condition even meant, of course, he was going to find it very difficult to work out whether or not it would have been satisfied, because he didn't know what it meant in the first place. And so in that type of situation, you can see why it's appropriate to look at damages as he did. But I mean, in the real world, in most cases, I mean, James, wouldn't you expect that the judge would, as on the facts before him, he or her, be able to make a decision on the balance of probabilities as to whether or not the condition would have been fulfilled?
I think as often as not, yes. And it's one of the, again, ironic sections of the judgment that, having gone around the houses and concluding that loss of chance is the right way to go about it, he then assesses the chance and says, well, it's so definite that I can award damages without any discount anyway. And you are left scratching your head and wondering quite what the point was. But in principle, I agree with you. Now, Paul, you were going to touch briefly on affirmation, and then we're going to move to
yes,
cure.
I was going to say I agree with Caroline on the last one, since we disagreed trenchantly on the one before. That must be right. You have a look at the evidence and you decide, would the let's say you've got a contract, would the performance condition have been lifted? And if you're able to come to a concrete conclusion, which normally you would expect to on the evidence, then if it's yes, it would, then it's contract market. If it's no, then it's probably nominal damages. I've got it. So I'm going to throw to the floor perhaps a slightly different question now. It's quite long. I'm going to just try and summarize it. So we have cases where vessels are delivered into time charter rather than voyage charter, even though negotiations are not quite yet finalized. In some of the cases, no agreement on some clauses could be reached. One question in this respect is whether owners or charterers could in this situation be entitled to argue, even after the vessel has been delivered, that there's no binding contract, and then perhaps pull out after voyage number one of who knows, great big long period time charter. I think that's a really interesting question. So this raises another of the points that was dealt with only obiter, a bit like the damages point, but there is a little bit of guidance on it, which is the question of whether and in what circumstances you can have an affirmation or a waiver of the unlifted subject. Mr. Justice Foxton's guidance there was that, well, it would be a rare case in which you had that. But if you had sufficiently unequivocal conduct to show that the parties were proceeding on the basis that this was a done deal, and despite the non-lifting of the subject, and conduct that was objectively consistent with them proceeding as if they were bound, then you can have an analysis where the contract's affirmed. Obviously, the reason why it's a rare case is because it effectively denudes that wording subject to supplier's approval of any meaning anymore. So you're effectively saying the parties put it into their deal, and then they decided to proceed and to waive it. So yes, on the facts, you could have that. And I think the example that we were given of the vessel actually being delivered and performing the first voyage is probably the sort of unequivocal conduct which might get you home. But then, of course, the interesting question is, well, is their conduct only consistent with them being bound to the whole 12 months, or is it rather consistent with them agreeing some sort of ad hoc, we'll do the first voyage but no more, so that they can't get to a waiver? Caroline, what do you think?
I think this is a really good question, actually, because I think it's really difficult. And doesn't it partly depend on precisely what the condition is. So let's go back to this wretched subject of board approval example for a different reason. Let's say this time charter party was subject to board approval. It seems to me that that type of condition, by performing the charter, that's undoubtedly been waived in this example. It's harder to think, as you've said, Paul, of a clearer example, but you can think of other details, other types of subjects that would make it more difficult, because if it is subject to details, let's say, for example, that some of the details concern the geographical range under the time charter. Now, merely performing the first voyage doesn't tell one anything at all about what it is the parties want to agree in terms of that geographical range, and how could the court possibly agree that for them? I don't mean, Nigel, James, your silks, this is when I might come sort of up to you and say, this is a good question, what do you think about this?
Well, I'm not sure there's much to add, Caroline, in the sense that you're right. I think it will depend on what is the outstanding area of agreement. If it is the geographical range, for example, or if particular ports or types of cargoes are going to be excluded, the discussions are over what particular ports or cargoes are going to be excluded, then it seems to me it's much more likely that the argument that there is no concluded contract, notwithstanding performance of the first voyage, is going to be a good one. Whereas, as you say, if it's something relatively minor, then either it's much more likely to be a performance condition, or the courts are going to say, well, by performance, the parties have reached a decision as to how they want to go forward.
Although there'd have to be some kind of quantum merit or something for that first voyage, because obviously there is, that the parties have done and agreed something in relation to that first voyage, and so you'd have to work out the consequences of that. But yeah, I completely agree.
Yeah,
well, I think there are three options, aren't there? I mean, either there is an ad hoc agreement for one voyage, otherwise on the terms of that had been agreed, such as they were, or there's no contract, in which case it's a claim and restitution. But the other possibility, of course, is that, and although the courts fight against it because they don't like having to deal with agreements to agree, one possibility is that the parties have in fact formed a binding agreement, but it just has a term in it on which they are going to have to negotiate. If they fall out over it in the course of the contract, well then it may be that the court can't give them an answer. But there's nothing to stop parties entering into contracts which contain clauses saying, well, if this happens, you will have to negotiate. And that may be the most comfortable and most commercial interpretation of what in fact has happened. But I think, as you say, Caroline, it's very strongly dependent on the facts and on the precise nature of the detail in question. Now, I'm going to draw a line under our discussion there and just try and draw some threads together. I think what one has seen from the discussion we've been having is that as helpful as it was in the case in front of him to resolve this question into this new terminology of performance condition and precondition, a couple of problems arise with that. The first, of course, is that we're going to have to map that terminology onto the existing blizzard of labels and terminology that already exists. And the second is that it's questionable whether all subjects can really be resolved into a binary choice between precondition and performance condition in the way that Mr. Justice Foxton assumes that they can in the Leonidas. But it's certainly an important case and a helpful one to move things forward. Now, we've been asked on the Q&A, what if the subject to shippers or receivers' approval is further qualified by the words not to be unreasonably withheld? Does that change this to a performance condition? Now, who'd like to pick that one up? Paul, you're bursting.
I'm sure I am. Maybe I think you'd have a stronger argument in favour of a performance condition on the basis that, as I think I've touched upon before, Mr. Justice Foxton's view was that in a case of a precondition, there's no room for any sort of preliminary agreement. You can all just sort of walk away. There's no agreements to agree and so on. Whereas in the case of a performance condition, you then go on to analyse what obligations the parties have undertaken with regard to lifting it, whether it's best endeavours, reasonable endeavours, and so on. And here you've got some actual guidance, some actual contractual guidance of what they had in mind there. So again, it's objective, look at all the circumstances, you know, is there a deadline? Is it wrapped up in a clause with a bunch of other subjects, etc., etc. But just taking it on its own, I think you're a lot closer to it being a performance condition with the implied obligation to take reasonable steps to ensure that the subject's lifted. What does everyone else think?
Well, my only comment in relation to that is that it looks and feels like an attempt to impose an obligation on people who aren't party to the contract.
That was my, I mean, if it was subject to charter's approval or not to be unreasonable withheld,
oh yes,
that would make much. Whereas the difficulty I have is if it's a third party's approval, then if the charter isn't in control of it, I struggle conceptually with that as a concept.
Well, that might then play into the counterfactual that Paul was hypothesizing earlier, where if you've got a very close link between the charterer and the supplier, they're in effect associated or subsidiary companies, then that clause makes more the imposing of what looks on the face of it like a secondary obligation makes a lot more sense and might well be thought to be pointing towards a performance condition. Whereas if there isn't that relationship, then you have to question, well, as James says, how do you impose that obligation on someone who's not actually a party to the contract?
Indeed. Well, with that, I'm afraid we're going to have to leave it there, partly because we've run out of questions to answer and partly because we've run out of time. Thank you all very much indeed for tuning in and staying online during this Quadcast. Our next Quadcast Shipping Special takes place on the 24th of November with Simon Rainey QC, John Russell QC, Sarah Peruk and Andrew Leung. You can catch up on previous editions on our YouTube channel. You're very welcome to subscribe to that, please do. And on Thursday, our Quadcast Live series continues on YouTube with an episode on contractual estoppel. But for now, that's all from us. Thank you very much and have a good day.
Cheerio.
Thanks very much.